Good morning, class. Welcome to PUP News. Today, we discuss the general principles of international laws. So what are these general principles? They have to do with sovereign equality and environmental law. Article 38 of the statutes of the International Tribunal for Criminal Justice states that the court shall apply international conventions, international customs, and general principles of law. General principle laws are secondary source of laws. The rules in states, meaning established states, are the rules in the international court, in international law. They have the right to be heard. People petitioning have the right to be heard by court. The operation of national law in the international law sphere is its primary. No state cannot plead innocence in absence of domestic legislation. The international court uses international law assisting in decisions. National law helps develop customary law, and national law is used as a basis for decisions of international law and tribunals. Now, the resolutions of international organizations assist in decision-making of international law, I think that's what that says. The enforcement procedures of international law are the Security Council, the loss of legal rights and privileges, and judicial enforcement. Traditional international law is enforced by international organizations. It's made up of individuals and non-state entities. Now, international law has expanded because of the creation of not sure what that means. International order? It's the recognition of individual rights. Judgment passed in Nuremberg. The international crimes are crimes against peace, crimes against humanity, conspiracy to commit, and ordered rules in war. Things that are ordered, the rules of war, are just that, the rules of war. The state jurisdiction over a person has territorial jurisdiction, nationality jurisdiction, universal jurisdiction, protective jurisdiction, passive personality jurisdiction, jurisdiction of armed forces, and jurisdiction over alien persons. The International Court of Justice deals with pre-existing decisions. The judicial decisions of the state, which are the judicial decisions of the state and national organizations. Customary and treaty law, on the other hand, when there's a conflict, you use just Coggins. I didn't write what that actually meant. There are two types of treaties. One is lawmaking. It has to do with territory and the rights of the individuals. Another is diplomatic. Consenting parties are bound vis-a-vis all other consenting parties. They are voluntary. They are qualifying existing customary laws. They are multilateral, which is a combination of qualifying and development laws. There's new principles of laws, and there are regional laws. The development of international law. There were no established states before the 16th century. Then came the rise of national states. Then came the rise of jurists. Hugo Grotius is considered the father of international law. The Treaty of Westphalia has to do with nation states, international law, and sovereignty. In the 19th century, this shifted towards liberty, equality, freedom of moral transportation, and the greater destruction of modern warfare. That brings us to judicial decisions, which are made by observing pre-existing conditions. When there is not a source of law, they can only offer guidance, and if they both have the same rule, then customary laws apply. And areas outside of exclusive jurisdiction of a nation are outer space, the Antarctic, and the Arctic Circle. Thank you. When we come back, I think we have more medieval stuff. Bye.